everybody. My name is Melody Block. I'm an attorney at Mandelbaum Barrett. I'm a partner in our corporate law department group. Today, we're here to discuss the topic of exit planning. Planning for your exit strategy can be very overwhelming, and therefore, we want to take this time to share with you some important considerations that you can evaluate. Things like your financial goals, the timing, the legal and tax implications of the exit planning choice that you may have, and how to prepare appropriately for a sale of your business to ensure that the transition is as smooth as possible. In this segment, our goal is to help restaurant and hospitality business owners identify some of the steps and issues that they can consider as they plan for their exit strategy. So let's get started. One thing that you want to do is definitely plan ahead and do your own diligence. By planning ahead, we usually recommend anywhere from 1 to even 7 years time planning for a potential sale and your exit strategy. You definitely want to do your own diligence before the buyer comes in and does their diligence. This process takes time, and if you're not planning ahead and you're not doing your own diligence, you could miss a lot of opportunities or run into big issues that can delay a potential transaction in the future. One of the things that you want to definitely do is keep accurate records, maintain a sales portfolio in case you're ever approached by the right buyer. You want to avoid things like unfavorable contracts. You want to definitely avoid signing contracts that have large penalties to terminate or that don't have favorable terms that a buyer may not want to assume. You want to review your liabilities, understand your inventory, make sure your financials are in good order and clean. Things like not recording a lot of cash transactions can negatively impact the value of your business in the future. Things like not maintaining appropriate insurance or having gaps in coverage can cause issues for the buyer in the future. And also, you want to make sure that you have all the government approvals necessary to run your business, as this will also be analyzed by a potential buyer. You also want to identify any liens or judgments or lawsuits that are against your business. You want to do this early in the process because no buyer will close a transaction on the sale of your business until all of those liabilities and liens are cleared. Next, we want to talk about your exit options generally. So what are they? There's a couple of ways to transition your business. Common structures will include an acquisition. An acquisition is usually in the form of an asset purchase transaction. This will involve an outside buyer or investor group purchasing your assets outright. The nice thing about an asset transaction is that it provides for very complete and thorough liquidity event, and will not involve a promissory note or future earnouts. Money that's potentially contingent on the business's performance. You'll get paid outright on the closing date. The buyers usually prefer an asset sale because they're able to minimize the liability that they assume at closing. The next transaction type is a partner buyout or a buy-in. If you've entered into a business partnership for the ownership of your restaurant or hospitality business, this means that an existing partner will buy your shares out or your units out. Or if you found an outside party that wants to join the partnership, that person can buy your interest in the business out. That's often structured in what's called a stock purchase agreement or unit purchase agreement. However, this structure does not always involve a full cash payment at closing. Sometimes it will involve a promissory note, and whether it does or not will depend heavily on your partnership agreement, what you've negotiated in a shareholder agreement or operating agreement. So before you endeavor to plan your exit strategy or before you endeavor to sell your business, you definitely want to know whether you have a partnership agreement in place and what it says specifically about the sale of your interest in that business. Your final option is dissolution or liquidation of the business. This is less than ideal. We want to avoid shutting down the business and just selling its assets as a last resort. But in some cases, it may be the only option, and it may be the way to help satisfy your debts. Each of these options, acquisition, buyout or buy-in, or dissolution, have different legal and tax ramifications. So we definitely advise that you consult with an attorney and an accountant before choosing any of these options. Our next point is that we definitely don't want to rush into any contractual negotiations. We definitely recommend negotiating what's called a letter of intent before jumping into contract negotiations and drafting. A letter of intent will memorialize the material terms of a transaction to make sure that both parties are on the same page about things like purchase price, restrictive covenants, how that purchase price is to be paid. Is it to be paid, like I said earlier, in cash at closing? Is it to be paid by way of promissory note? What are the security interests? Are there any earnouts? What are the employment terms that are required? What is our underlying real estate situation? Is the buyer also purchasing real estate? Are they entering into a new lease? Are they assuming a lease? These material terms will all be outlined in a letter of intent, and we make sure that the parties are on the same page as to these terms before we start paying lawyers to draft contracts and negotiate them, which is a longer process. The letter of intent will also set expectations like the closing date, and will have important provisions in them such as confidentiality clauses and exclusivity clauses. Before you enter into any type of negotiation with a potential buyer, you want to make sure you have an NDA in place, a non-disclosure agreement, but that letter of intent will also have a confidentiality provision in it. And if you're on the buying side, you definitely want to make sure that your letter of intent has an exclusivity provision. An exclusivity provision prevents the seller from simultaneously negotiating with you and with other parties at the same time. While you're negotiating your transaction documents and while you're conducting diligence, you don't want to be wasting time and resources while the seller is potentially negotiating with other people, other third parties. The next topic to consider is, again, your underlying real estate. What is your real estate situation? Do you, as the seller, person planning for your exit strategy, own the real estate upon which your restaurant or hospitality business is on, or do you lease it from a third-party landlord? This will affect the buyer's future transaction as well. If you own the real estate, for example, are you willing to sell it to the buyer? What is that purchase price going to look like? Have you obtained a formal valuation of the real estate? And how will you be paid for that purchase price? If you don't own the real estate and instead lease it from a third-party landlord, we would definitely want to review that lease agreement early on, understand how that lease can be assigned to a future buyer, future tenant. Is that assignability clause favorable for us? Is it unfavorable for us? Will we be required to obtain landlord consent? Are there other conditions that need to be met either by the tenant or the future assignee of the lease? These are all things that we want to know ahead of time. We don't want to discover them as we're in the process of negotiating a transaction because they can often delay the transaction and cause unnecessary costs and waste of resources. If you're not looking to sell your real estate and instead you're looking to act as a landlord to the future buyer, we also need to consider things like fair market value rent, and what type of lease you want to enter into as the landlord. Do you want to enter into a triple, double, or single net lease? What are the responsibilities of the tenant going to be? Are they going to be responsible for things like maintenance, insurance, taxes? That will all need to be spelled out in a lease and therefore should be considered as you're planning your exit. The last thing that we want to share with you, a topic that you should consider as you're planning for your exit, are restrictive covenants. You definitely want to know what your post-closing plan is. Are you looking to retire, move to Florida, play golf every day, or are you looking to enter into another business venture or a joint venture with someone else? Answering these questions is really important because the buyer is coming in and purchasing the goodwill of the business and all of the reputation that you've built throughout the years. If the buyer is paying a hefty purchase price for that goodwill, they definitely don't want you opening up a restaurant down the street or within a certain mile radius. We call that a restricted area. So you want to define those plans, those post-closing plans before entering into a transaction, so the buyer is clear on your plans, and so you're able to negotiate a fair and reasonable restrictive covenant. We would like restaurant owners and hospitality business owners to consider all of these tips that we've shared, and hopefully they will ensure a smooth and mutually beneficial transaction and help you plan for your exit strategy. Our team has extensive experience working with restaurant owners and hospitality businesses. Our law firm has over 100 attorneys and over 30 practice areas. The benefit of working with a diverse law firm such as ours is that you're able to tap into the expertise of real estate lawyers, environmental lawyers, corporate lawyers, and all of the needs of your transaction will be met because they will all involve issues like this. For more information, please contact us, and thank you for listening.